Order. The clerk will now proceed to read the orders of the day.
Item 1, the Criminal Justice Reform Bill, second reading.
Minister for Law.
Mr. Speaker, sir, I beg to move that the bill be now read a second time. This bill is closely related to the next bill on our order paper, the Evidence Amendment Bill. Sir, may I therefore suggest, with your permission, that the debate on both bills take place now, as both these bills are closely related. Members would be welcome to raise questions or express their views on both bills during this debate, but we would still have the formal second reading of the Evidence Amendment Bill as well to ensure that the procedural requirements are dealt with. However, the proposals to have the substantive debate for both bills take place now to avoid duplication or overlap so that all substantive arguments can be captured cogently in a single debate.
Please proceed.
Thank you, sir. Mr. Speaker, the government has made important changes to the criminal justice system over the past decade. These changes have been towards a more progressive, balanced, and modern criminal justice system that protects society from crime. In 2010, we repealed and reenacted the Criminal Procedure Code, or the CPC, after a sustained period of review of more than 2 years. In 2012, we amended the Evidence Act to reduce the stress that complainants of sexual offences experience during the court process. In 2012, we made calibrations to the death penalty regime, and in 2015, the government began funding of criminal legal aid through the Law Society. The amendments in these bills continue in this spirit. Let me recap the key principles which underpinned the revisions to criminal procedure in 2010. First, the presumption of innocence must be respected. Second, there must be fair processes. They must reflect a balance between various interests, and each society must decide for itself what a fair balance is. Third, accurate outcomes. The system must be effective at arriving at the truth to ensure that the guilty are held accountable and the innocent are not convicted. The current amendments are made with the same principles in mind. We made a sustained effort to obtain and consider feedback. Public consultation was held for a month in July to August 2017. We received around 30 contributions from a wide spectrum of society, the general public, civil society organizations, banks, technology companies, and the bar. We also had an extensive dialogue with the Law Society and the Criminal Bar from the start of the public consultation until January this year, when we had a dialogue with the Criminal Bar, and then we took on a number of their suggestions. The Law Society President, Mr. Gregory Bajendran, acknowledged this in his address at the opening of the legal year 2018, when he said, "The Bar appreciates the constructive consultations we have had with the Ministry of Law on amendments to the Criminal Procedure Code. The Law Ministry officials have shown considerable respect for the Law Society's perspectives, a number of which were accommodated. Even when we agreed to disagree, the process was positive and the dialogue candid." Finally, there were ongoing consultations with the judiciary, the Attorney General's chambers, and other ministries. There was broad support for the amendments proposed. I would add that we are concurrently in the midst of a fairly fundamental review of the Penal Code. The Penal Code Review Committee comprises representatives from the judiciary, AGC, the Criminal Bar, academia, and the government. The proposed changes to criminal procedure that we are discussing, taken together with the changes or the proposed changes to the Penal Code, will put our criminal justice system on a strong footing going forward. Let me now deal with the overview of the changes. The amendments can be split into three main categories. First, investigative processes. Second, court procedure. Third, sentencing powers of the court. Under these three categories, there are more than 50 discrete proposals. I will not go through the technical amendments in detail, although members are welcome to ask questions, but I will briefly cover the non-technical amendments. Let's start with investigative processes. and the introduction of video recording of interviews, or VRI. Under the current law, law enforcement agencies taking statements under the CPC can only do so in writing. The bill will allow such statements to be taken via video recording. This will assist the courts to try cases more effectively when investigation statements are sought to be admitted in a criminal trial. First, they will be able to take into account the interviewee's demeanor when deciding on the weight to be accorded to the statements. Second, video recordings also provide an objective account of the interview to assist the court in deciding on any allegations made about the conduct of the interview. The implementation of the VRI requires significant investment of infrastructure and training. It will therefore have to be implemented in phases. In the first phase of implementation, we intend to make it mandatory to conduct VRI for suspects in rape offences under Section 375(1)(a). However, we recognize that there may be instances where there is a need for exceptions. These will be set out in the legislation. For example, there may be a need to record a handwritten contemporaneous statement from an accused person at the scene of the crime when the person is arrested at the scene. The legislation allows for flexibility to take into account such operational exigencies. The next set of amendments relate to the powers of investigation relating to evidence stored on computers. Crimes increasingly involve the use of computers, smartphones, and the internet. We are enhancing the computer-related powers of investigation in the CPC to keep pace with this evolving environment. Investigators will be able to order the production of evidence stored on computers where such evidence is in the subject's possession or power. Our investigators have also been analyzing and searching through large amounts of data. To increase investigators' efficiency when processing electronic evidence produced under such an order, the amendments will allow regulations to be made to specify how such production orders must be complied with, including the format of the reply and the method of delivery. This is intended to enable electronic replies in machine-processable formats. We've conducted industry stakeholders who provide data to our investigators and have taken into account their feedback in determining the requirements that will be imposed. Investigators will also be empowered to access, secure, and safeguard evidence on computers, regardless of whether the evidence is stored on a computer inside or outside Singapore. Many people now use web-based email accounts or web storage accounts. Technically, such data may reside in computers outside Singapore, even if the data is accessed from within Singapore. Applicable laws in other countries will be duly considered when such powers are exercised. The bill makes us next on to search of women suspects. The bill makes a small but important amendment to the search powers of police officers and immigration officers. Currently, women can only be searched by female officers. The amendments will allow a male officer to search a woman in specific circumstances. These are if the officer reasonably suspects the woman of involvement in a terrorist act. Second, the officer believes in good faith that the terrorist act is imminent. And third, the officer believes in good faith that the search cannot be made within a reasonable time by a woman officer. This will allow searches of women suspected of being terrorists where time is of the essence and any delay could mean loss of lives. Next, strengthening the bail regime. I'd said in late 2014 that the ministry would be reviewing the framework on bail. This was after the 2014 hostage-taking incident in a Sydney cafe, perpetrated by a person who was accused of a serious crime and yet had been released on bail. He went on to take 17 innocent persons hostage in a Sydney cafe. The incident eventually led to the death of 2 innocent persons. There is a need to strike a balance. On the one hand, the presumption of innocence means that it would be unfair for someone accused of a crime to be kept locked up in remand when he or she has not yet been found guilty by a court. But on the other hand, there must be sufficient means to secure the accused person's continued attendance in court to ensure justice is served. The system must also ensure that those who may pose a danger to public safety, are at risk of reoffending while on bail, or who may interfere with evidence are not released on bail. With these considerations in mind, the bill strengthens the bail regime in a number of ways. First, the bill makes certain adjustments to the categorization of bailable and non-bailable offences. It may be helpful if I clarify for members the meaning of bailable and non-bailable at this point to avoid confusion. If an offence is bailable, it means that the accused person is entitled to bail as of right. And if the prosecution objects, then it is for the prosecution to show why the person should not be granted bail. If an offence is non-bailable, on the other hand, the accused person is not entitled to bail. He or she must show the court why bail ought to be granted. If they fail to do so, they will be remanded. In practice, many accused persons charged with non-bailable offences are released on bail with conditions intended to ensure their attendance in court. On that note, we are making certain offences non-bailable. Cheating under Section 420 of the Penal Code. This brings cheating in line with the treatment of other similar offences carrying similar penalties, for example, criminal breach of trust, or CBT. Offences which concern false evidence and offences against public justice will also be made non-bailable. These offences relate to interference with the administration of justice. Second, the court's powers relating to bail and personal bonds will be clarified and enhanced. For example, important bail or bond conditions, such as to surrender travel documents or to surrender to custody when required, will be imposed by default unless the court orders otherwise. Many of these conditions are in fact already ordered by the court as a matter of course, but this will further tighten the system. Electronic tagging or e-tagging will be allowed as a condition of bail. This will assist the police in monitoring accused persons who have been released on bail. The court will be given the discretion to withhold bail for bailable offences punishable with imprisonment if there are substantial grounds to believe that the accused person would abscond. The rules on execution of bail pending a bail review will be tightened if the state courts grant bail for a non-bailable offence and the prosecution intends to apply to the High Court for a review of bail. The state courts will be required to order that the accused person is not allowed to go on bail until the review is determined. In other words, the accused person will have to be remanded until the High Court decides on the bail review. If the state courts grant bail for a bailable offence and the prosecution intends to apply for review, the state courts will have a discretion on whether to allow the accused person to go on bail pending determination of the review. Third, the bill creates 3 new offences to ensure that bail remains effective. It will now be an offence to abscond while on bail or personal bond, leave the jurisdiction without permission for persons whose travel documents have been impounded by investigators, and indemnify a surety, or if you're a surety, to agree to be indemnified. I now move on to court procedure and evidence and the proposed amendments for enhancing protection for victims of sexual and child abuse offences. In the past 2 years or so, there has been a concerted effort to ensure that vulnerable victims of crime are sufficiently protected by our criminal justice system. One particularly vulnerable group of victims are those who are subject to sexual or child abuse. We have re-examined every step in the system to minimize the trauma that such victims experience in the process of bringing perpetrators to justice. Some measures have already been implemented by the police. For example, the one-stop center for medical examinations to minimize waiting time for sexual crime victims, enhanced training curriculum for police officers to better handle sexual crime victims' cases, and the pilot of a multidisciplinary interview, or MDI, model for children who have been sexually abused. These bills introduce a suite of measures to further enhance protection. Let me highlight a few examples. First, the publication of information leading to the victim's identity will be automatically prohibited even before the case goes before the courts. One of the fears that victims have when deciding whether to report sexual offenses is that media coverage will cause them further distress. This is why the courts often grant gag orders to prevent the publication of information that may lead to the identification of a victim. However, the case must actually be before the court before such an order can be granted. This means that if a person gets wind of the identity of a victim and the case has not yet come before the courts under current law, that person can make public information revealing the victim's identity. Some suspects may even do this to intimidate the victim and make them basically pay a price for making a police report. To prevent this, the bills will move the restrictions upstream. Anyone who knows that another person is an alleged victim of a sexual offense will not be allowed to publish any information that may lead to the identification of the victim's identity. So, for example, a person could have confided in a colleague that she was the victim of a sexual offense. If this colleague makes public the fact that the person was such a victim, the colleague would be committing an offense. And this applies even if the person has not reported the offense to the police. Second, all victims of sexual or child abuse offenses will give testimony in a closed-door hearing unless they wish to give evidence in open court. Third, we will amend the Evidence Act so that we can put in place subsidiary legislation that restricts the kinds of questions the defense can ask. They will not be allowed to ask questions about the victim's sexual behavior with persons other than the accused, where such behavior does not relate to the charge unless they have leave of court. Application for leave must be made in the absence of the victims. This will help prevent a recurrence or reoccurrence of the incident that the press reported on late last year, where a defense lawyer embarked on a line of distressing questions when cross-examining an alleged victim of molestation. Finally, Clause 77 will allow the video-recorded statements of vulnerable victims, such as victims of serious sexual offenses, to be used